After Mr. Robert Joseph Mettle-Nunoo had sworn by oath for proceedings to begin, Mr. Akoto Ampao, lead counsel for the second respondent, raised an objection that paragraph 17 to 32 of the witness statement of Mr. Robert Joseph Mettle-Nunoo be struck out due to the fact that he, Mr. Robert Joseph Mettle-Nunoo, had signed and swore for the truth of only paragraph 1 to 16 of his witness statement. Mr. Akoto Ampao further objected against some paragraphs in the witness statement of Mr. Robert Joseph Mettle-Nunoo, basing his argument on the fact that these paragraphs were not born out of the pleadings of the petition filed by Mr. John Dramani Mahama. The paragraphs included 4, 5, 6, 7, 8, 10, 11, 15, 16, 17, 18, 19, 20, 22, 23, 24, 29, 30, and 31. However, paragraphs 9 and 21 were also objected based on the fact that the witness didn't plead these paragraphs for authenticity. Paragraphs 12, 25, and 26 were additionally objected on the basis that they were irrelevant and must be struck out by the court. The lead counsel for the first respondent, Mr. Justin Amenufo, associated himself with the objections raised by Mr. Akoto Ampao. However, Mr. Chachuti Kata, the lead counsel for the petitioner, John Dramani Mahama, nonetheless opposed the objections raised by the first and second respondents. He argued that Mr. Ampao's objections are baseless and should be overruled by the court. According to him, the witness statement of Mr. Mettle-Nunoo also provided answers to issues raised by the chairperson of the first respondent, Mrs. Jane Mensah. Honorable Dominic Aini, MP for Bolgatanga East and former Deputy Attorney General, stated in an interview that they were happy with today's rulings since most of the paragraphs in Mr. Robert Joseph Mettle-Nunoo have been maintained even though they were sought to be struck out by the second and first respondent. He added more to this.
Of the press. This morning, the petitioner presented his third witness in the person of Rojo Joseph Mettle-Nunoo, and a witness statement prepared and signed by the said witness was filed before the court, and we were expecting that he was going to give his evidence today. The lawyers for the respondents, particularly the lawyers for the second respondent, Nana Addo Dankwa Akufo-Addo, raised a number of objections to the paragraphs of the witness statement. In fact, they raised objections to 23 out of 32 paragraphs of the witness statement. And the basic objection they raised was that those paragraphs, in terms of the evidence that was sought to be given, did not arise out of the pleadings of the petitioner. They sought to say that those paragraphs should have been reflected in the pleadings of the petitioner. However, a basic rule of law, which I'm sure was lost on them, is that in pleadings, you plead facts, but not evidence. And we had pleaded the facts that were necessary to ground our petition, and this witness statement was designed to provide evidence in support of the facts that we have pleaded. So, for instance, we made it clear in the petition that the chairperson of the Electoral Commission had acted in an unfair, arbitrary, and capricious manner. And the evidence of Rojo Mettle-Nunoo, together with the evidence of Dr. Kwesa White, which I'm sure you witnessed the other day on the 3rd, was meant to make it clear the extent to which the chairperson was capricious, was arbitrary, and also unfair as far as the petitioner's case is concerned. And so we were taken aback when they sought to basically throw out the entire witness statement, saying that it was not supported by the pleadings. But as you have seen, I'm sure the court took a different view, and out of the 23 paragraphs in respect of which objection was taken, it was only 5 of them that the court said should be struck out. And for us, that is a great victory. We will not comment on the substantive content of the petition, of the witness statement, because he's yet to be cross-examined on them. And I'm sure on Monday, when we return to court, the cross-examination will take place. And thereafter, if there are any issues arising out of or in connection with the cross-examination, we'll address you and clarify those issues to your understanding.
Designate Minister of Information Honorable Kojo Oppong Nkrumah, however, cautioned the legal team of the petitioner not to be taken away by the sudden turn of things in their favor. He also added more to this.
Like they say, it's one thing putting something before the court, it's another thing defending it when it comes to cross-examination. And so counsel on our side, and we believe counsel on the side of the first respondent, look forward to an opportunity on Monday to now put the paragraphs that have been admitted in Rojo's witness statement to the test under cross-examination. Essentially, that is what has happened today, as I'm sure you are aware. We are happy that finally Rojo will be in the witness box so that some very important questions can be put to him and the bench or the court can take judicial notice of whether or not those answers to those questions and those arguments that are being proffered go in any way to help deal with the issues before the court. And as I wrap up, let me take you through the issues. Sometimes when you follow the long conversations, you forget what the court is trying to answer. The court is answering one question of law, 3 questions of fact, and 1 question of law that arises as a result of a fact. The question of law is whether or not the petitioner in his petition has any reasonable cause of action. The questions of fact are whether or not, based on the data, nobody got 50%. Whether or not the Article 63.3 threshold was met is a question of law, as I've mentioned earlier. But whether or not you include or exclude Techim and South, does it change? And then the other question of fact is whether or not all the so-called errors and vote padding affect the outcome of the presidential election results. The last question of law, which comes from fact, is whether or not the declaration will therefore be in violation of Article 63.3. If you find that at all material times Nana Akufo-Addo exceeded the 50% threshold, then that question of law will be answered in his favor, that then it was not unconstitutional. So we believe that we are making progress gradually. We are at a point where the third witness will be put in the box and we'll see whether his argument stands up. What is interesting to note is that when our colleagues don't get a win in the wells of the Supreme Court, when they come, they say the decisions don't make sense, that the court is not being fair to them, etc. But today, you notice that as they got some of their arguments upheld, they seem to think that the court is the best so far. But we'll live to see what is out ahead of us. They describe it as a great victory. And let me explain to you why they describe it as a great victory. They describe it as a great victory because they realize that Dr. Kpetsahoi's testimony fell flat, could not stand the test of time. And therefore, they've tried to bring in Rojo, who initially they came with some reasons not to bring, so that he can, and if you listen to the arguments of counsel for plaintiff, Mr. Chachuchi Kata, he makes the argument that during cross-examination, some very significant damage was made to the argument. And therefore, it is proper for them to bring in Rojo to try and re-establish some of those ones. So for them, if many of them had been struck out, it would be a very devastating day because then it goes to buttress the point that where Rojo failed, where Kpetsahoi failed, nobody can attempt to save him. Now, they seek to bring in Rojo to try and save Kpetsahoi where he fell flat. And we are pleased that at least they are no longer trying to poison the minds of the public against the court. We look forward to what Monday will bring.
Meanwhile, the Supreme Court, in a consensus decision, struck out 5 paragraphs of a witness statement filed by the NDC's Robert Joseph Mettle-Nunoo in support of Mr. John Mahama's election petition. These paragraphs are 4, 5, 6, 7, and 18 have been struck out based on reasons that they have no foundation in the pleadings or supported by the evidence. The remaining paragraphs in the witness statement have therefore been maintained. This leaves some 27 paragraphs out of the total 32 submitted by the witness. The court has adjourned the proceedings to Monday, February 8, 2021 for cross-examination of Mr. Robert Joseph Mettle-Nunoo.